Hello, everybody, and welcome to another amazing episode of Unstoppable Success. I'm your host, Jaclyn Strominger, and on this podcast, as you know, we hear from amazing leaders and influential business professionals who are out there doing all things to help make them unstoppable, and they get to share their insights, their tips, their wisdom with you so you can be unstoppable too. And today I have an amazing guest, Austin Bonderer, and let me tell you a little bit about Austin. He is a seasoned patent attorney with over 2 decades of experience. He has a huge portfolio, over 700 issued U.S. patents, underscoring his expertise and dedication to the field. And his professional journey has taken him from across the globe, enriching his perspective and broadening his knowledge. And let me tell you, that's a lot of patents. So, welcome to Unstoppable Success.
Well, thank you for having me.
You're welcome. Okay, so I'm just kind of curious. Did you wake up and come out of the womb thinking, I want to go into patents?
No, I was part of a generation. When I went into the patents, I have to tell you, most people did not seek it out. I have to say now I get, Instagram DM messages, "Hey, I want to be a patent attorney." That wasn't really how it happened back then. I went to engineering school. You have to be an engineer or a scientist to be a patent attorney. So I was going to engineering school, and part of my capstone senior thesis, I developed this wireless smoke detection system. And I got really interested in, and I wrote my own provisional patent, which is horrible now looking back, but I did it. And this was, part of my thesis. I filed it and all stuff, but it got me interested, and the patent office was hiring. So I went and worked at the patent office as a patent examiner.
As a patent exam, I mean, okay, so like there are things that you just don't think about in terms of professions that are out there. And patent examiner is not really on my list of like number one professions that come to mind. I'm just letting you know, right?
I agree. I agree. Trust me. I thought I was going to do the engineering stuff or construction management because that's kind of where I was headed. And then it was like, no, you're going to sit in a back room and research all day and then write papers and push them. And that's going to be your life now.
Okay, so what made you go from that back office to now attorney?
Okay. So a lot of times I honestly at the time I didn't want to live in Washington, DC my whole life. Okay.
Okay.
And that was the issue. Like, so at the time, the patent office didn't have it where you could work remotely or anything. So, in order to leave DC, and I wanted to raise a family and all this other kind of stuff, you had to go to law school. So I went to law school at night, became a patent attorney, then started working on the other side.
Okay. So now you're a patent attorney. I mean, one of the things that I see, and talk to me about this, you know, and I and I know there's a big, huge um, differential. Patent, trademark, and then then you also have like a registration for a name, right? Like,
So the
okay,
trademarks, that's the names, right? So that's the registering. And the whole point of a trademark, most people don't realize this. So what I do is I help people get federally registered trademarks. And as you mentioned, the difference between the TM and the R of the circle. R of the circle means it's registered. The TM means you're claiming a common law trademark. So you'd be surprised what brands still use TMs, like American Airlines. They use a TM. They are not a federally registered trademark. Now, that
what?
doesn't mean that, well, they got issues because when you trademark a name, you pull it out of the lexicon, right? So American Airlines literally describes exactly what it is. So they could never stop Delta from saying Delta is an American airline.
That's true.
Right. So they came up with a name. So that's one of the things when you work with your clients and you're trying to get some separation there, you definitely go out and try to find a name that it's not descriptive because it will never become registered. You try to look for strong marks, which tend to be a little bit more fanciful. Like when Google came out, there wasn't a such thing as Googling. It was just Google or Yahoo or stuff like that. So what you get a trademark as soon as you put a service or product out into commerce, right? Then you have common law rights to it. Now, to make it stronger, what we try to do is we federally register it. One of the requirements is that you have to have interstate commerce before you apply for the federal registration.
Okay. I'm
Yeah.
like interstate commerce. Okay. Okay. Yeah.
Yeah. So for some reason, the government can regulate everything in the world in the United States, despite the interstate commerce clause. But for trademarks, no, we still need the across state lines thing before they get involved. So that's what they do. So you have to have the interstate commerce and the name. And then once you do that, you can have a federally registered trademark. And what that does is it protects you throughout the United States. Because a common law trademark will be geographically limited. So just say you're a Southwest chain or something like that, and you don't get a federal registration. If so happens that someone in New York opens the same type of restaurant, the same type of name, you can't stop them from using it. But
Interesting.
had you got a federal registration, you would prevent everyone in the United States.
Interesting. So when people are starting a business, and this is a part like for listeners, I think this is really important. If you are planning to be and work, I guess, interstate or globally, I don't, you know, is it really important right from the beginning to get to talk to an attorney and say, hey, like, I want this, check my registration, trademark, whatever.
Yes. I mean, so it's definitely one of those things you can, you know, it, definitely in the United States, internationally, if that's what you want to do, you can do what's called an intent to use application. And basically what it is sometimes say that time is of the essence. You will actually apply for 4 different marks with the intent to use them. And it's almost a form of pre-clearance. So
Yeah.
once you get that clearance, hopefully you get clearance on all of them, and you can decide to use the one that you like the most. But, say that 1 or 2 falls, now you have one, something in backup. Because if you're like, hey, we got to hit the presses, within 9 months, because understand it takes a while to get for your registration process to go through
Right.
or your intent to use application to go through. I think the backlog now is 7 months from the date of filing until they look at it.
Oh, gee.
Well, for
Okay.
patents, it's 2.5 years or so.
2.5 years. Okay, so let's talk about patents because I'm kind of curious about this too. Because, you know, like I could tell you, like I've had a whole different bunch of different ideas and I've never gone through with them because I think, oh, I should get a patent for it and blah, blah, blah. I need to get a prototype made. And then you see these companies that pop up and say, hey, you've got an idea. We will help you. Cheesy
Yeah.
grin, right? And you're like,
Yeah.
you're cringing. I can see
Uh,
that.
I can't tell you how many clients have come to me after working with, those kind of companies. I'm not going to name names.
Yeah.
Uh, in fact, if I'm not mistaken, in the 90s or 2000s, Congress actually passed a law, consumer protections against those type of
Oh,
companies. I could be wrong. Don't quote me on that. I was a little bit
okay.
younger at the time, and I'm much older now. I forgot some things. But in any case, um, th- what I tell people who call and they've dealt with it, I'm like, look, if you feel like you're the product, you are the product. So if you feel like you're being sold, that's where the money is coming from.
Yeah.
So, right. So I always tell people, be careful. Don't, you know, because their business model is generally they will make money if your invention hits. They'll take a percentage of it. But in the meantime, if it doesn't hit, they're still making money because they're like, we need you to pay us to contact all these companies. And it's like, well, what does contact all these companies mean? It might just be junk mail,
Right.
but that's contact, right? I mean, there you go. We need all these brochures made. We need all this websites made. I mean, just the way that they push your product and all of it is expense to you. And if it hits, they still get a percentage of your patent. Right.
Yeah, that's not great. That's, I mean, so Because yeah, I mean, I've spoken to different companies, and one of the things that they say, if you have an idea, come to us. We're going to help you manufacture it. We'll help you come up with a prototype. We'll give you get the patent. And I'm like, actually, I just want so many people just want the first part, which is help me make the prototype. I don't want the other stuff because I'd rather use another person for that.
Right. Exactly. Yeah, I know. Like the I try to help my clients the best I can, but I do have my wheelhouse. I am a patent attorney. Now, I do have experience with startups, so I help with business and stuff. And, I can turn into that nagging. I always say I'm like the nagging mom saying, clean your room. I'm like, we need to sign these agreements before we get too far down the road, because
Right.
inventors and entrepreneurs are like, we're making this, is happening now. And attorneys are like, slow down. We have to do the boring work first, but the
Right.
boring work can make it work. You're right. So I would not suggest using those companies. You can find people to make your prototype much better. Let them stick in their wheelhouse.
Right.
Um, and here's the other part you were talking about. You had a product. First thing I tell people who call is like, you don't need a patent to make money. I mean, look around your house. You pay good money for a lot of that stuff, and someone made money off of you buying it. So, if it's a good idea and you can't get a patent on it, you can still make money.
Right. You can still sell it. You just have to get somebody, do the prototype and then start doing those things, right? If that's something that you really want.
Right. And this is a thing, like there is a sweet spot. You can make a very good living on something before it gets copied. I
Yeah.
mean, there is a sweet spot. Like, I mean, you have to be making a ton of product generally before someone's going to copycat
Copy it.
you in your product. Yeah. So, if you could make a happy family life with a good product that's selling, maybe, and then add to that product line before you start getting, you know,
Right. So you know, when is the right time to then go get the patent?
at the beginning. Unfortunately, it's front loaded. Trademarks you can get a registration anytime. I actually had a client that had been in business for over 70 years and we registered their trademark,
Oh,
right? So, but with patents, disclosure kills patents. So if you publicly disclose or offer for sale your patent or your idea, you only have a year in the United States to file for a patent application, but you've generally lost your right in the EU, China, a lot of other countries. The United States tends to be very patent friendly, and a lot of these other places are not. So any public disclosure can ruin your right to file in those countries. So generally, what we would do is we file in the United States first, and if you're like, hey, it's going to be a big deal, then we can file in the other countries. But if you publicly disclose while you're still able to file in the United States, you can't file overseas.
so do you have an example of somebody that you say, okay, this company made X. We did it here, but we couldn't do it overseas.
Well, it's not so much made. Just if you have a patent in the United States, you have the exclusive right to make and use it in the United States. But China can make it and they can sell it all over the world, everywhere else. Right.
Right.
So that's kind of how
So,
that works.
yeah. So, but you don't necessarily have to get a patent just on a product, right?
No, you
Or
can,
there's different types of patents.
well, generally for a utility patent, you have a patent on either a method or an apparatus.
Okay.
They have basically killed software patents. It was the Alice decision came out. Supreme Court said, this is just ones and zeros, electrons. Therefore, it's an abstract idea. And in
Okay.
a weird way, they were right. Basically, what it is, the way I explain to people, because I get calls all the time. Hey, I have a new app. I want to patent it. And I'm like, well, is it generally taking information, comparing it to a database, or running through an algorithm and spitting out an output? And pretty much all apps are that. It's just, the secret sauce in that algorithm or database. And you can't get a patent on it because technically someone could do that in their head.
Okay. All right.
And you can't patent thought.
right,
Yeah,
right,
yeah.
right,
That's
right.
that's kind of the way it goes. Yeah, exactly. So, but so you can generally patent methods and apparatuses. But I warn my clients because a lot of times they're like, "Hey, I came up with a new way of making something." I'm like, "Yeah, we can get a patent on that, but then we tell everyone how you're making it. But how do we enforce it?" Methods of manufacture, because it's happening behind a building, like inside a building. How am I supposed to know that they're using your patented method? You told them how to use it because you have to teach someone how to make and use your invention, but there's no way to police it. So oftentimes we'll talk about it and like, is it something that a trade secret would be a proper remedy in order to protect, that secret sauce? And of course, the most famous trade secret of all time is Coca-Cola, right?
Right, right.
So,
It's a right, a formula, you know,
right.
right? Okay, so that's a trade secret. So does a company get a separate
There's
filing for a trade secret? Or does
no,
that,
there's no really such thing as a filed trade secret. You just have to go through a lot of steps. And, each situation is different. Like, say you have a manufacturing process, you might do, that component behind four security doors, so only very few people see it. I mean, if you're going to try to protect it as a trade secret, make sure you talk to an attorney because it's a lot less concrete as a patent because a patent comes in a document. You're like, here, the government gave it to me. It says it right there. Trademarks, registration, same thing. Trade secret's kind of like, we did everything we thought possible to keep this secret. Court, will you please enforce our trade secret against this rogue employee that's going to try to give it away? That's kind of how it works. And then the judge is going to look at you like, what did you do to keep it secret? If you're like, we just made everyone sign confidentiality agreements, that's not going to be enough.
I'm sorry, I don't mean to laugh about that, but I feel like that's like, you're like, not that NDAs are confidential it's just, you know, I find that's, correct me if I'm wrong. I would imagine sometimes that some of those things are really hard to enforce. If you're just having a conversation with somebody, sometimes you don't even realize what you're saying. I don't know. It's
Well, there's a big thing with, I've seen a lot. So an NDA at the end of the day is a contract. And a
right.
lot of people are like, hey, I told my best buddy, and don't worry, he signed an NDA. And I'm like, well, what did you give him in exchange to keep quiet? Because in order to have a contract, you have to have a quid pro quo, like something for something. And his promise to keep it quiet, or your best friend's promise to keep it quiet without something given to them, is merely a promise and not a binding contract by any means.
Right.
The other thing is, no one seems to read it. It's like in there, it says if you give out documents, you need to say it's confidential. If you talk to people, you need to say it's confidential. Like you have to label everything that you believe is confidential in order to adhere to the terms of the NDA. So it's not just this blanket piece of paper, like, here you go, I have an NDA, it covers everything. It's like there are responsibilities inside that document that you have to live by. And if you're not doing it, then you might be in trouble later.
Right, right. So, and so many people I don't really think necessarily read the fine print.
No. I mean,
Right.
I mean, I only do because someone pays me to, right? It's so monotonous, and I wonder if that's where AI will start to come in and then you ask these people sometimes like, how'd you sign this contract? And you're like, well, I didn't. It was 15 pages long. You expect me to read that? And I'm like, I get it. I mean, I read 5 pages of that stuff. I'm sleepy. I can't imagine like someone who doesn't, it's a lot of
Okay.
work.
Yeah, so I have a question and I find it interesting. I'm hoping my listeners will find it interesting. Um, with with the impact of AI, let's say I have a company and I'm putting in all the information about the company into AI to help me generate all my marketing materials, blah, 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 right? At what point, you know, is there a lack of protection of intellectual property because now I have put all of that into AI, and AI can pull from anywhere. So how do we define, I guess, and keep intellectual property with AI?
Yeah, I've been harping on this for a while because everyone's like AI, and I have people call me and be like, "Hey, can you file this for me? I had AI write my patent application for me." I'm like, I'm sorry, I can't do that, and I wouldn't trust it either.
Right.
But there are people who are like, I'm going to search and see if it's out there. So they put in their idea into AI. And I've always said until a court tells me that's okay and not considered public disclosure, because I mean, you're literally giving your prompt, your description to the largest database out there, at least one of them, right? How is that not public disclosure? Strange enough, just read a case I think it was out of New York federal court, and it had something to do with attorney-client privilege. Someone put these questions into AI or this information into AI. They somehow got a hold of it. They tried to claim it was attorney-client privilege. The court came out and said, if you look at the terms of service, they're allowed to keep your prompts. They're allowed to keep all the information that you put in there. Hence, that's a disclosure to a third party unrelated to the litigation and therefore breaches attorney-client privilege. Now, that's not the same thing that we're talking about patents, but to me, public disclosure is public disclosure. So
Right.
still, I think my idea is being reinforced. Do not put your idea into the AI prompts
Right.
to see.
Right. Because and this is actually a really big thing, listeners, because I want to bring this up because on a business side, and there's a little personal part of this with me, if you're in business of somebody, right, and you have a separation, but you both have been putting all your stuff into AI, there's no more intellectual property. It's if it's all in there. Like it's out there for anybody to see. It's in a database. Correct?
Well, I don't know how, I'm not an expert in AI. I
Yeah.
just know they kind of own the information you put in, but I don't think that someone can literally be like, tell me what these people said.
Right.
Right. I don't think it's that how that works. I could be wrong. You know, I'm not a computer guy.
Right. Right.
I
I
didn't
think I
like,
might have to do a couple of prompts. So
I know,
tell me,
I know.
chat and Claude, can you tell me whatever?
Yeah,
I think it makes it more like null and void as you put it, if you're sharing ideas and you're sharing information about your business, right? And you're putting it
yeah,
out there, right? And it's not in a private behind a firewall.
yes. I think I know what you're saying now. So that's the other thing about NDAs. They only protect confidential information. And if you put everything in AI, there's a good chance that it's not confidential anymore. So therefore, all the NDAs that you signed with other parties is now null and void. That's a court case. That is judges. That's going to go up federal circuit, possibly Supreme Court. That's where, but I don't want to be the test case, and I don't
Right.
want my clients to be on the wrong side of that. Now, it could be decided in the other way. Like the Supreme Court may say this is so, you know, far removed from disclosure. Like someone can't just come up and say who said this and what did they say, but it's now integrated into a friend of mine likes to say the Borg. It's
Right.
now part of the Borg, and nerd reference. Sorry,
Right. No,
but
I
the
get it.
yeah,
I'm nerd with you, so that I get it.
yeah. So it's in there, but I don't think it's easily accessible at this moment. So I don't know how that actually falls. Being an attorney, we're always like slip and falls, don't get hurt. Dangers everywhere. Don't do it. So I mean, but you got to move fast in business. There are risks that sometimes you have to take. If AI is getting you to the market fast, I always say lawyers can lawyer you right out of business.
Right. That is true. That is really
Yeah.
true.
We'll suck up all your budgets.
Right.
You will have the best company that has no money to sell anything. I promise. right?
So I love I love the fact that what we're talking about is it's really about protecting our assets when it comes to some I mean it really brings to light to protect yourself from um harm in your business when you're getting out there. And with AI right now, it's really it changes how you actually do research on your product and your ideas. So in that sense, is it, and I'm just going to say, let's say I take my idea and instead of me obviously putting it into chat, I say, okay, Austin, here's my idea. You're the patent attorney. Can you do a better global search of my idea if there is something that's similar out there before I start going down the path of trying to create this? Because I don't want to use AI because I'm now putting my idea out there. So do you as a patent attorney and other patent attorneys become this the gateway to ideas so that you're get idea protection?
Right. Yeah. So I don't actually know how that's all going to hash out. So I don't know how good AI is at searching for products. You know, I just heard something crazy today about they developed an AI so advanced on developing software that they're afraid it can turn into like just hacking everything. Like it found something in a software that's been used for 30 years. No one's ever found these bugs. It found something that could make it control the internet or something. I forgot what it was. So they're crazy how good these tools are. I just don't know how it would work for searching. Um, what I would think is, so we do it the old-fashioned way. We have to do it with non-disclosure agreements. We keep it private. We do all the stuff. Now, once your product gets out there, there's no harm in throwing in AI.
Right.
So people who want to invalidate your patents may throw all this stuff in there and be like, search the entire world, because our searches are done by humans. It's an art, not a science. You know, I used to be an examiner. The search I conducted on Wednesday and the references that I'd pull on Wednesday would probably not be the exact same if I did the search on Thursday, because you're focused on certain paradigms, certain days, a little bit off here and there. You hope that the core is there, but you
Right.
might have pulled a different one over here, a different reference over there on a different day. That's just the nature of human beings. AI, boom, I don't know what's going to happen.
Yeah. Right. So when we're I have a friend of mine who developed a product and she does have a patent on it. It's actually quite cool. Um, but so again, I guess I would put it like this. It's like if if listeners want to have, sort of that success with their product, go make sure that you've explored the patent with a patent attorney before it goes out to everybody and their brother. You can still make money. You can, but as you said, have that year, but protect yourself.
Yeah. So I always get the question, when do I know I might have something that's patentable? And I'm like, generally, it's when you've solved a problem. Because if you've solved a problem, it might be a problem that everyone's had, you know. And so that's generally what inventions are. They're just solutions to problems that we've had or problems we didn't even know we had sometimes. And, that's how it works. And so get a patent attorney. My suggestion is companies get on a really good relationship with a patent attorney, an IP attorney. I mean, but you should also have a good business attorney, right?
Right.
Your business insurance should have patent coverage in it, like patent infringement, in case someone sues you, in case you have to sue someone, right? I don't think they have it offensively, but they definitely have it defensively.
Yeah.
Um, so you should definitely, those are the kind of things. Like I said, that's the stuff that I help businesses with sometimes, after they develop their product and they're moving forward. Hey, can you help me with some of this business on the back end? Um, but if you have a good relationship with a patent attorney and they know what you're doing, and then also with your trademarks too. So you say you're developing products and you're moving into different areas, you need to protect those names. I had a client that came in one time and I was like, you guys should have went because understand trademarks are classes. So you can have Acme Oil Company and Acme Fragrance Company, right? That's not trademark infringement because they're in different classes, much, far apart. But, they came to me and I was helping them with it. I'm like, you should have gone over here and they got usurped by someone else.
Right.
Right. And just because you have a trademark in one class doesn't mean you have it in all classes.
Right. You need to act, but that should be part of a search too, or
Well,
using.
the reason that happened was because they were not close enough with their attorney for their
Uh,
attorney to foresee where they were going.
okay, got it. Well,
Yeah.
that's
So,
actually a really cool thing. It goes to building. It's you need to you. It's not you're. It's not like patent attorney for hire, so to speak, in the sense of like just you're not putting the coins, right? You know what I mean? Right? Like you
right.
really need to have that relationship so that they do know what you're doing. Just like your CPA, your
Yeah.
like your business attorney, like they all need to know what's going on in your business. I mean, I always look at like that's part of your, if you had to make things efficient every year, get those people together in a room and say, okay, here's what we're doing in our business. You guys all need to make sure that we're all up on board, right? Like all on board.
Right. Exactly. And it depends on the attorneys you have. Some of them will charge you for all that. Some of them are just like, hey, I enjoy having the relationship because that kind of stuff. So you should, it's, I equate it to kind of like your doctor. You gotta let your doctor know what's going on, right? They keep your business and healthy. All your attorneys do too, and your accountants,
Right.
right? I mean, what is that old saying? Like, my dad used said, three people, you need a good doctor, a good lawyer, and a good accountant, right? That's what your business needs to.
Right, right. That's true. And it's when I think about that right now, so many people don't have those. So if you don't have those listeners, get them. Get those all.
Right.
So Austin, tell me what is your next big thing? Like what are you really working on? And what keeps you going?
Well, it keeps it going. I really enjoy what I do. I mean, like I enjoy working with people. It's when I have a client who truly, I mean, I hate to say it. I tell people when they first call, like independent inventors, you may want to take this money and invest it in the stock market. It's less speculative than, trying to develop a product. You know, patent is one thing, but it's a small step in actually developing a business based around an idea that you have. That's a lot of work.
Right.
It costs a lot. If it succeeds, it's going to be great. If it doesn't, it's painful. But I have to tell you, when I'm with a client and they got a red ball and it's just taking off and it's doing everything, that's why I got into this is, to see that stuff. And it really is great to see people making it work. And I got to tell you, like I've seen great ideas. I've patented them for or helped them patent them. But as we all know, it's not the idea, it's the idea and the execution. And it's
Right.
sometimes it's that hard part because there's a lot of question marks in there to get to profit. Like, how do I produce this? How much money am I going to spend? What marketing do I do? And that's hard for one person to get all those right in order to make this thing happen.
But and I guess that's also comes down to like having somebody, in your back pocket like yourself, where they actually um have somebody sort of rooting for them and who also has seen, you've seen the good, the bad, and the ugly. So somebody's going to come to you and they're going to be like, okay, Austin, well, this is my what I want to patent, whatever, you being able to help not just advise, but say, okay, making sure that you have these other things in a row, ducks in a row.
Yeah, exactly. I mean, and that's the thing. Like, I stay in my wheelhouse. Like, I'll have people come to me and be like, hey, I have this idea for an invention. Do you think it's going to do well? And I'm like, I've worked too long because there have been times I'm like, this is going to kill the market. This is the greatest idea. This is the coolest thing since sliced bread, goes nowhere. And then other times I'm like, are you sure you really want to spend all this money on this? Like, are you sure? And then sure enough, right as rain, they had the conviction, they had everything, they made it work, and it was very successful. So when it comes to marketability, That's someone else's
That's somebody
forte.
else's
That is
job.
not my wheelhouse. Yeah, exactly. I is not I I do the legal stuff. I can I get you a patent? Can I not get you a patent? Maybe. I don't know, but yes, the marketability that's on you.
Well, I love it. Well, Austin, I could talk to you for hours about this because I think it's so fascinating. And I'm so curious as to like where AI is going to take it because as we said, like there's so there's some areas obviously like putting it in, right? Right. And there's gonna be some changes down the road that I think it's gonna be fascinating to see what
Me
happens.
too. I had the coolest thing, and just one more thing, about AI, and I think, I think we're okay, most of us, because we're at least the shepherds. We know what a patent attorney, in your business or whatever, like we know what it's supposed to be. The problem is the young kids coming up, or the youngins, they won't have the 20 years of experience to see that AI did something wrong.
Right. Right.
Yes, we'll get to a point where no one if AI is right or wrong. Because I've spent 20 years writing patent applications, office actions, arguing this and that. I know the stuff. It can it can put out something that looks really, really good, but I'm sure there are problems with it. And if the young people keep using that, they're not going to have the experience to point out when it's wrong.
Right. Oh, that's
So the
actually really
shepherds,
scary. Right.
we're the
I'm
shepherds. Yeah.
I'm that makes me a little nervous about a lot of different things. So on that note, Austin, how can listeners get in touch with you, find more about what you are doing in way of obviously patents and and helping people? How can they connect?
Well, it's probably easiest to find me on the internet. Bonderer. I'm the only patent attorney in the United States with that last name. So you
Okay.
put in Bonderer and patent, you will find me. You'll see my work, but my website should pop up. And feel free to give me a call or an email.
All right. Well, that's great. Well, we will put your website link in the show notes so that people can reach out to you. And listeners, please do me a favor. Connect with Austin. This stuff is so important for your business, and I would hate for you to miss something so critical in your business. So, get Austin in your back pocket because you may need a patent attorney. So do me a favor, reach out and connect, and then please make sure that you hit subscribe. And lastly, Unstoppable Success, we have a brand new community on the school platform. So please jump in. It's Unstoppable Success on School and you can find us there. Please jump in and join us. It's going to be free for the first 100 people, and then we may have some other things on there, but we've got great courses that are going to be coming out, so you want to take part in that. And Austin, thank you for being a great guest. I really appreciate it.
Well, thank you for having me.
It's such a pleasure. And listeners, thank you for listening. I so appreciate each and every one of you. I am Jaclyn Strominger, your host. Keep being unstoppable and leap to your greatest success. I'm Jaclyn Strominger, and I want to invite you to join the Unstoppable Success community on School. You can go to Unstoppable Success at school-9143 and join us. In this community, you will get daily tips so that you can be unstoppable and you'll also connect with other leaders and professionals who are also aiming for their unstoppable success and are there to help you succeed. So join us in the community. We can't wait to see you on School.